morning. So we have two cases on the docket this morning that are going to be argued, three on the docket total. Are both of you arguing both of these cases then?
I think there's only one. The other one was a late submission.
Okay, so which one was the late submission?
Sean Allen on behalf of the state on the Heath case.
On Heath case, so Osterman has been submitted, okay. All right, well, let me then read out the docket, all right? Thank you so much. So today is Wednesday, July 20th, and welcome to the First District Court of Appeals. All right, so we have three cases on the docket. Case number C200387, State of Ohio versus Heath, which is going to be argued this morning, right?
Yes,
okay.
Correct.
If you can identify yourself and your readiness to proceed.
David Hoffman for the appellant, ready to proceed.
Sean Allen on behalf of the state of Ohio, ready to proceed.
Excellent. Then we have two more cases that have been submitted. Case number C200415, State of Ohio versus Osterman, and C210371, State of Ohio versus Haynes. So we can start whenever you're ready with regard to State of Ohio versus Heath. Now, normally we allot 15 minutes, so let's address that first, because I know on some of these cases we've allotted more time. Does either the state or the defense, do you feel like you need more than the 15 minutes to argue the case?
No, Your Honor. As a matter of fact, I was going to suggest that the court decide the second assignment of error with regard to the Reagan-Tokes issue, hold it for decision in State versus O'Neill that the court has already heard argument on and is under submission.
All right.
And I think Mr. Donovan,
That's correct, Your Honor.
Okay.
Mr. Hoffman and I spoke, and we both agreed that we believe that's the adequate course unless the court had questions.
Okay.
This issue has been thoroughly litigated.
All right, so if we have any questions on Reagan-Tokes, we'll ask them. If not, if you want to proceed on the other assignments of error.
Very well. And so to make a long story short, the 15 minutes will be fine.
Okay.
We'll just argue, I wanted to argue the weight, manifest weight claim.
All right. And would you like to reserve time?
5 minutes for rebuttal, please.
Very good. Whenever you're ready.
Okay, please the court, Mr. Donovan. This conviction is contrary to the manifest weight of the evidence, and the evidence of regarding identification is contradictory and not sufficient in violation of due process. Kiana Allen testified that she's a victim in the case, that an identification was certain at trial when she had not been able to identify my client as the person driving this van. During an interview on May 25th, 2015, at the time of the photo lineup, she said she had never seen Chantel Heath before, or her sister Shanisha. And in a trial, she said that 10 times she had met these people and expressed a great familiarity with them both. And she testified to an immediate identification to this person, my client, at the time of the event at trial when that facts just indicated that it was not the case. So my claim has to do with identification, and the evidence tends to indicate that the driver of the van, that Miss Allen believed that it was Shanisha, Miss Chantel's sister, that was the driver of the van. Her testimony even began with an identification of Shanisha as the driver when the prosecutor put a stop to it and put her back on track. In Miss Heath's opening brief, it was argued that Kiana Allen, she was so certain of identification, if she was so certain of her identification from the get-go, that the photo lineup would not have been necessary. And then the state in its answer brief said, well, she was in the hospital, she couldn't have been contacted immediately, and so an investigation was necessary into the identification of the driver because her input wasn't readily available, and so that would explain the use, the hours spent on BMV records and tips in that as a source of Miss Heath's identification.
So the car was registered to her?
Correct.
Okay.
Well, it wasn't at first. It was on the 23rd. This happened on May 11th of 2019. The 23rd is when the registration was changed into my client's name. But there is
Who was it registered before that? Is that in the record?
No, but there is in the record a video of a damage claim that my client made when she refers to it as her car. And that was only 3 or 4 days before May 11th, the event. It was May 8th. And so there is some evidence of ownership before and after. But I believe that would be a basis.
And wasn't you were trying to undermine that because of her disability, whether or not she could drive the car, but doesn't that counter the point you're just making?
A little bit, yeah, it does. But her being a paraplegic still is relevant because Miss Allen claimed that her identification of my client, twice she said this, she was able to identify my client because the windows of this van were down. And if you watch the video, all the videos that were accumulated on this case and are entered into evidence, they all show the windows up in this van. And the difficulty of driving a van with your hands and not with your feet at all, and then putting the windows up and down. I mean, say they
But was
were
the
up
van,
most of
was the
time.
van retrofitted for
There was no
somebody who's
evidence.
a paraplegic to be able to drive it?
No evidence of that.
Oh,
I mean,
okay.
there was no direct evidence. I mean, circumstantially, if she told a police officer 3 days before the event that it was her car, you might be able to
Assume,
assume or infer that it was.
right.
But even if it had been, her ability to, I mean, those windows were up throughout. There's no depiction of them being down as the van was, going on the sidewalk and going after people. If that were true, she would have had to put those things down right as when she was addressing.
Mr. Huffman, like all of the points you're raising, like these could be really compelling points to the trier of fact, but and sound like great cross-examination points for Ms. Allen. But how do we get around the fact that these seem like questions for the trier of fact?
Well, when you weigh the evidence, the conviction can be contrary to the manifest weight of the evidence, and this is all evidence I'm addressing, and the evidence indicates that it's not.
So you're making more of a manifest weight than sufficiency.
Yes, but it's sufficiency in the sense that the evidence must be reliable. You can't be convicted on unreliable evidence. I think it would be a violation of due process, and in that sense, I think that there has to be some standard with a sufficiency claim that the evidence has to be met with. When Miss Allen was questioned about her photo ID of my client, it was in the context of a question of who was involved in her injuries, and that's when she identified my client. When she was asked who was responsible for her injuries, she answered it was Shanisha, and so that goes beyond just a fodder for cross-examination. That's evidence that tends to indicate that it was my client's sister and not my client who was driving the van. And so if you just give me a second, I want to run through these things to make sure I've gotten everything. I think I have addressed the points I intended to make. If there are no further questions, I would ask that the court would reverse the conviction and remand for a new trial. Thank you.
Thank you.
Your Honors. I guess I'll pick up where Mr. Hoffman left off in the discussion about the photo lineup and involved rather than responsible. Actually, the discussion, I believe on page 44 of the transcript, Ms. Allen specifically says that the driver of the silver van is the person that she is identifying from that lineup, and that person was the defendant, Chantel Heath. She had some confusion because she was shown multiple lineups on that day, and the confusion and the discussion about that is, well, where's the other person? Where's the other driver? Referencing the sister in that matter. But clearly and definitively on page 44, she says that she is identifying the driver of the silver van, not the sedan, but the driver of the van. And that discussion is pages, I believe, 43 through 45 of the transcript. So I don't believe that that is contradictory and that undermines her credibility in this matter. Additionally, to go to that, Mr. Hoffman described the May 25th, which is when the photo lineup being shown as an interview. Well, no, the interview was conducted by Detective Miller, I believe at a later date. At that date, it was Detective Smith who was showing up, who was a blind administrator who knew nothing about the case, and by definition of being a blind administrator, cannot know anything about the case, and testified as to that. She would not be conducting an interview. She shows up with the pictures and the photo lineups that Detective Miller had independently developed through his investigation and showed them to her. So it wasn't an interview on that date. So any perceived inconsistency at that time, once again, we don't believe is demonstrated by the record. Detective Miller's, well, I'm going to backtrack now and I'm going to go back onto my roadmap, as they would say when we were in law school. And that's the primary focus here is the credibility and the reliability of Ms. Allen's testimony as to that it was this individual, Ms. Chantel Heath, who was driving the van on that day. And in terms of the reliability factors, traditionally it's been opportunity to observe, level of attentiveness, level of certainty at the time of the identification.
And was there any issue regarding her, Ms. Allen's mental faculties after the accident? Like, was there any, in terms of her ability to recall, was there any sort of like brain trauma or anything by virtue of the accident?
My recollection from the record, sir, is that there was a discussion about her initially being on medication, that she was in the hospital for 6 months, and that it was that she went through 9 surgeries. So there were times where she was dealing with anesthesia and pain medication, but the impact and everything was from the waist down. And it was her lower body. I believe it was mid-leg is where she was impacted and pinned between the vehicles. So there's no indication that I'm aware of that there was any head trauma or anything like that that would impact that. So because going back to the reliability factors, because she's in the hospital, and Detective Miller testified that he didn't have an opportunity to discuss her. His research and his investigation was developing independently of her. That's why he spent the days doing the BMV searches and trying to develop this and reviewing the different videos and everything like that. So level of, the accuracy of the pre-identification description isn't relevant in this matter because there wasn't an opportunity to that. He didn't interview her until after the lineup. In terms of the videos, as we discussed a little bit, the criminal damaging video from the body-worn camera from the previous incident shows possession and ownership just prior to the incident. And it also depicts the distinctive damage and window stickers that are subsequently compared to the videos from the scene of the incident itself and from the Shell station around the corner, where while the driver of the silver van, which the evidence would say and we would argue is the van that is in the Shell station is clearly Ms. Heath's van, is speaking. You can't see that driver in the Shell video. You can see Ms. Heath's sister and the other car that's involved in this incident talking in an animated way with the driver of a van that circumstantially had to have been modified for somebody with Ms. Heath's capabilities to drive. Therefore, another person is unlikely to have been driving that van on that particular day.
How do we know that? Or you just
There's
infer?
no direct evidence. Yes, Your Honor, I'm making a couple of inferences to get to that point.
Because it was registered to her.
Because there were the temporary tags. She made the report, referred to it as her van, and then subsequently registered it. That shows possession and ownership during the entire time to include the incident. And so The videos corroborate her testimony that I saw this person 100%. She's the one. She had plenty of opportunity to see her as the van and the other car driving around, and she's looking at them and she's trying to dodge them. And then when she's pinned face to face, pinned against the other vehicle, she has ample opportunity to observe, and her attention is solely focused on that individual. And if I can have one moment, just wanted to see if there are any questions that I hadn't. I don't believe there's anything else that I wanted to address today if there are no further questions.
Thank you.
In summary, I just want to point out that Ms. Allen's testimony didn't just involve a confusion with regard to the name of the accused, whether it was Chantel or Shanisha. She was presented with the photo lineup at trial. And when asked who was responsible, if she could identify from the lineup, she said, "Where's the other photograph?" She didn't say, "Yeah, this is the person." It wasn't just the name that there was a source of confusion. It was the photograph as well. And so I think that there's enough evidence here to indicate that this conviction is contrary to the manifest weight of the evidence because it was from Ms. Allen's testimony, it was clear she believed that it was Shanisha, not only by name but also by photograph, that was the driver of this van. So
Was the sister ever charged, or do we know?
That's not in the record, Judge. And also, I'm not sure what the how that
I was just curious.
how that happened. All right. If there are no further questions, I would ask that the court reverse and send back for a new trial. Thank you.
Thank you.
Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and that concludes our arguments for today. Thank you.